Hello students, in the present lecture of Indian Penal Code, I am going to discuss with you important provisions of Indian Penal Code which are from section number 57 to 66 of IPC. Section number 57 will discuss how to calculate fractions in relation to terms of imprisonment. Section 60 will talk about sentence may be in certain cases of imprisonment wholly or partly, regress or simple. Section number 63 will talk about how to calculate the amount of fine. Section 64 will states that what will happen if there is failure of payment of fine. That means section 64 will talks about sentence of imprisonment for non-payment of fine. 65 will talks about what will be the limit in relation to imprisonment when there is failure of payment of fine, when the offense is punishable with imprisonment and fine. And at the end we will discuss the provisions of section 66 of IPC, in which we will deal that what type of imprisonment will be when there is non-payment of fine. Okay, let us start the video from section number 57. Section 57 states that in calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. Now, most of the students will say that it means that imprisonment for life is equal to the imprisonment for 20 years. The answer is no, because section 57 of the code does not state that imprisonment for life shall be reckoned as imprisonment for 20 years. It is very important to know that a prisoner's sentence of life imprisonment will not automatically come to an end by lapse of 20 years. Only for the purpose of calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years as per the provision of section 57. In a very important case, Supreme Court of India has made it clear that in calculating fractions of terms of punishment of imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. And that case was Subhash Chandra versus Krishan Lal, 2001, Criminal Law Journal 1825, Supreme Court. It was held by the Supreme Court that section 57 of IPC provides that in calculating fractions of terms of punishment of imprisonment for life shall be reckoned as equal to imprisonment for a period of 20 years. It does not say that imprisonment for life shall be deemed to be for 20 years. What is the position of law according to Supreme Court of India? The position at law is that unless life imprisonment is commuted or unless life imprisonment is remitted by the appropriate government under the relevant provisions of law applicable in the particular case, a prisoner sentenced to life imprisonment is bound in law to serve his remaining life term in the prison. Okay, so this was something about section number 57. Thereafter, section number 58 and 59 has been repealed. Now let us study what is written in section number 60. Section number 60 states that in certain cases of imprisonment, sentence may be wholly or partly regress or simple. In every case in which an offender is punishable with imprisonment. I want to repeat what is stated in section number 60. In every case in which an offender is punishable with imprisonment, which may be of either description. That means it may be punishable with regress imprisonment, it may be punishable with simple imprisonment. Either description means it is punishable with rigorous imprisonment or it may be punishable with simple imprisonment. In every case in which an offender is punishable with imprisonment which may be of either description, it shall be competent to the court. It shall be competent to the court which sentences such offender to direct in the order of sentence. That court can direct in the order of sentence that such imprisonment shall be wholly rigorous, or that such imprisonment shall be wholly simple, or that any part of such imprisonment shall be rigorous and rest of the part of imprisonment will be simple. But it is very important to note here that section 60 talks about when the sentence is for imprisonment. It do not talk about imprisonment for life. So imprisonment for life in the code means a rigorous imprisonment for life and not simple imprisonment, meaning to say that life imprisonment is always the rigorous imprisonment, it cannot be simple imprisonment. Whereas when the offense is punishable with imprisonment of either description, then it may be simple imprisonment or it may be a rigorous imprisonment, wholly or partly. Okay, so what is section number 63? I want to clarify that section number 61 and 62 has also been repealed from Indian Penal Code. Section number 63 states that what will be the amount of fine when nothing is mentioned in relation to the amount of fine. What is stated in section number 63? It states that where no sum is expressed to which a fine may extend. That means to say where no maximum amount of fine is expressed in the provisions of Indian Penal Code, then the amount of fine to which the offender is liable is unlimited. But it is very important to note that amount of fine shall not be excessive. So I want to repeat the provision of section number 63. It states that where no sum is expressed to which a fine may extend, the amount of fine to which the offender is liable is unlimited but shall not be excessive. It is very important to note that offense and penalty must be proportionate to the nature of the offense, but a heavy fine which the accused is unable to pay should not be imposed by the court. Okay, so this is something about section number 63. Now let us study what is written in section number 64 of Indian Penal Code. It states that what will happen if there is failure of payment of fine. It states that sentence of imprisonment for non-payment of fine. Section 64 states that in every case of an offense, which is punishable with imprisonment as well as with fine, in which the offender is sentenced to a fine, whether with or without imprisonment, first of all, and in every case of an offense which is punishable with imprisonment or which is punishable with fine or which is punishable with fine only, in which the offender is sentenced to a fine. So the common thing in para number 1 and 2 is that the offender is sentenced to a fine. It shall be competent to the court which sentences offender to the payment of fine to direct by the order of sentence that in default of payment of the fine, the offender shall suffer imprisonment for a certain term. What will be that term? We will discuss later on. The offender shall suffer imprisonment for a certain term, which imprisonment shall be in excess of any other punishment. Such imprisonment shall be in excess of any other punishment to which he may have been already sentenced by the court, or to which he may be liable under a commutation of a sentence. So this is something about section number 64. What is stated in section number 65? It is very important. What will be the limit to imprisonment for non-payment of fine when imprisonment and fine are avoidable? It states that what will be the limit in relation to imprisonment for non-payment of fine when imprisonment and fine are avoidable. The term for which the court directs the offender to be imprisonment in default of payment of fine shall not exceed 1/4 of the term of imprisonment, which is the maximum fixed for the offence, if the offence be punishable with imprisonment as well as with fine. I want to repeat that the imprisonment in default of payment of fine shall not exceed 1/4 of the maximum punishment when the offence is punishable with imprisonment as well as with fine. So what is written in section 65? I want to repeat it. The term for which the court directs the offender to be imprisoned in default of payment of fine shall not exceed 1/4 of the term of imprisonment, which is the maximum fixed for the offence, if the offence be punishable with imprisonment as well as with fine. So this section applies to all cases where the offence is punishable with imprisonment and fine, or with imprisonment or with fine. It does not apply to cases where fine only be imposed. Okay. So section 66 will tell us that what will be the description of the imprisonment when there is failure of payment of fine. It tells that what will be the description of imprisonment for non-payment of fine. It states that the imprisonment which the court imposes in default of payment of fine may be of any description, but it depends upon the main offence for which the offender is sentenced. Okay. The imprisonment which the court imposes in default of payment of fine may be of any description to which the offender might have been sentenced for the offence. So if the main offence is punishable with simple imprisonment, the person will be liable in default of payment of fine with simple imprisonment. When the person is liable for the main offence with rigorous imprisonment, then the person in default of payment of fine will be liable for the rigorous imprisonment. If the main offence for which the offender had been sentenced is liable to imprisonment of any description, then imprisonment which the court imposes in default of payment of fine may be of any description. So if the offence is punishable with simple or rigorous imprisonment, then the additional imprisonment in default of payment of fine shall also be simple or rigorous, as the case may be. So this is something about the present lecture. If you like my lecture, then please like my lecture in this YouTube, and if you want to get the notifications of my next videos, then please subscribe my channel if not subscribed yet. And if you want to get notes of my law lectures, then you can go to Google and type law articles 2020.blogspot.com. You will find number of notes which have been written by me in my blogs. Thank you very much.